Good afternoon, folks. We're going to wait just a little bit here to let attendees file on in, and then we will get started shortly. Good afternoon, everyone. I see people just slowly joining. We're going to wait a minute or two more before we dive in. Thank you so much for being here this afternoon. We will get started in a little bit. All right, well, for the sake of time, let's get going here. First off, welcome everyone. Thank you so much for joining us this afternoon for this really important conversation. We're going to be discussing the path to reproductive freedom today. And this town hall is going to focus on Roe v. Wade and abortion rights in Wisconsin. And I'm thrilled to be here this afternoon on behalf of the ACLU of Wisconsin and joined by some of our fantastic partners from Planned Parenthood Advocates of Wisconsin as well, to talk about this really important issue and to take time to dive more deeply into what this means for Wisconsin as a whole. So as we consider who we have in the room today, I am joined by three fantastic panelists and myself. So my name is Abby Canyon. I am the Community Engagement Manager for the ACLU of Wisconsin. And I am joined by my counterpart, Chris Donahoe, who is a staff attorney for the ACLU as well on our legal team. And then from Planned Parenthood Advocates of Wisconsin, I am joined by Mike Murray, their executive director, and Michelle Velasquez, who is the director of legal and advocacy services. So thank you all three of you for being here with me today, again, to talk about this really important issue around abortion rights and reproductive rights. For those of you that may not be familiar with the ACLU or the American Civil Liberties Union of Wisconsin, I wanted to take a moment to acknowledge our mission and our vision, which we are here to protect and promote civil liberties and civil rights of all of the people of Wisconsin in a nonpartisan manner. And we envision a diverse society that better understands, values, and protects civil liberties and civil rights. So we do this through a variety of avenues. We use educational practices through town halls such as this. We advocate on behalf of people's civil rights and civil liberties, and when necessary, we rely on litigation tactics as well. And for our partners in the room from Planned Parenthood Advocates of Wisconsin believe that all individuals should have the information and means to decide the number and spacing of their children and should have access to basic preventative health care. Planned Parenthood Advocates of Wisconsin engages in legislative and educational activity and works to elect candidates who support these goals and to state and federal offices. So in today's town hall, I want to take a moment just to do a brief overview of what we'll be covering. I want to be really clear about some of the goals that we have through this town hall and through our time with you today before jumping into discussing the fundamentals of reproductive rights and abortion access. We'll then turn our attention to looking at an analysis of the Supreme Court draft leak that pertains to the Dobbs v. Jackson's Women's Health Organization that was released about 2 weeks ago and what sort of implications it has on abortion rights in the state of Wisconsin. So we'll really focus in on a state level what this means for Wisconsinites. And then I know many of you are probably here today asking yourself that really important question of what else can be done and how can I help to make my voice heard and protect this crucial right? So we will take time in the next hour or so to cover all of these topics. And in the spirit of transparency, the goal of this town hall is really to break down the nuances of this complex issue, to talk about how abortion is an essential right and form of healthcare, and then also discussing some of the nuances of what all of this legal jargon can mean for the lay person. So discussing the processes and protocols that go into making these important decisions, and then looking even further ahead to talking about scenario planning. So what could we see playing out in our state in the near, medium, and long-term future? And then also discussing avenues for community mobilization. So again, thinking about how you can make your voice heard around this very important topic. And I don't want to take up too much airspace here because we have a lot of important information to cover today. So I am going to turn it over to Michelle, and she will begin discussing some of the fundamentals about reproductive rights and abortion services. So please, Michelle, feel free to chime in.
Thanks so much, Abby. Thanks everyone for joining us this afternoon. I think it's important to get started in any discussion about the Dobbs versus Jackson Women's Health Organization case and its implication for Wisconsin with just a brief review of the current legal framework under which abortion providers in Wisconsin are able to provide the care that they do. So Roe versus Wade, which was decided in 1973, was a case before the United States Supreme Court in which that court decided whether or not a state can stop a person from having an abortion. And the court in that instance held that the Constitution protects privacy, and embedded in that right to privacy is the pregnant person's freedom to choose an abortion without the excessive government restriction. And so that's really the foundation of abortion rights under our federal Constitution. About 2 decades later, Casey versus Planned Parenthood of Pennsylvania was decided. And I think that's a case that people thought was an opportunity for the US Supreme Court to strike Roe down and to overturn that previous decision. But the court didn't. The court upheld that foundational right that it had found in Roe versus Wade and carved out really the sort of framework that we see today for how states are supposed to regulate abortion and what their sort of limits are in doing that. So states can regulate abortions before a fetus can live outside of the womb, but it can only do that if the purpose of the regulation isn't to create an additional obstacle or make it more difficult, simply just to make it more difficult for that person seeking the abortion. And that's been the framework that we've had now for nearly 50 years. I think even before Roe, it's important to know sort of what that legal landscape was as well. And so when we're thinking about what Jackson Women's Health Organization decision might mean for reproductive rights in Wisconsin, and we're not just thinking about abortion, we're thinking about other forms of reproductive rights we have. It was only in 1972 that birth control was legalized by the US Supreme Court for all women, regardless of their marital status. Prior to that, only married women with the consent of their spouse could get a prescription for birth control. Before Roe, abortion was illegal in about 30 states, which included Wisconsin. And of course, we know that abortion still existed before Roe. And I think, as we'll see now, people with the financial and other resources have always been able to access abortion care in places where it's safe and legal. And it's those individuals who can't travel, who don't have the social connections or other resources, who have to either continue with their pregnancy or use some other mostly unsafe way to end the pregnancy. And all of that caused, of course, harm and even death to people. And that, I'm speaking specifically about before Roe. Just so people are aware, there are 2 types of abortions. There's a medication abortion and in-clinic abortions. Medication abortion is a 2-pill regimen, and one of the pills blocks the production of the progesterone and the other to induce the miscarriage, to essentially stop the pregnancy from being viable. And then the second pill induces the miscarriage or to expel the tissue. Administration of medication abortion in Wisconsin is very heavily regulated. we have some of the most restrictive and burdensome laws in the country. Medication abortions are done up to 11 weeks of gestation, and they account for about 50% of abortion services nationwide. And then, of course, the in-clinic abortions are surgical procedures.
And now I think, Mike, we're going to turn it over to you to learn more about reasons why an individual would be seeking abortion services.
Absolutely. Thanks so much, Abby, and thanks, Michelle. We really appreciate the partnership from the ACLU of Wisconsin and the opportunity to share space with you all this afternoon. Thanks for having me. So I was just going to go over a few slides just to provide a little bit more kind of basic background information around the reasons people may seek an abortion, some of the myths around abortion, and sort of what the existing landscape in Wisconsin is currently around abortion access. So there are oftentimes many reasons that an individual who can become pregnant may seek an abortion, and sometimes those reasons actually overlap in a web of sort of decision making that people go through. But in general, these are sort of the primary reasons why someone may seek an abortion. One is that they simply may not have the financial ability to support raising another child or to pay for healthcare. Second, they may have existing family and life responsibilities that they need to attend to that is not consistent with either having to go through a pregnancy or support another child. Some individuals may be going through some sort of health circumstances that may necessitate an abortion. So, for example, a couple of examples might be in relation to the health of the fetus. So sometimes women or other people who can become pregnant who very much have a very wanted pregnancy are given news that that pregnancy is simply incompatible with life. There are some fetal diagnoses that involve such severe complications that a healthy pregnancy and a healthy birth are not possible. Those health reasons also may be due to health reasons for the pregnant person. As many folks probably know, actually, abortion care is actually far safer than going through a full-term pregnancy. And oftentimes there are other health issues that may be impacting a pregnant person that may necessitate the pregnant person accessing abortion care to protect their own health. Unfortunately, some people also are maybe in a situation where they or their families are not in a safe place to be able to go through a pregnancy or to raise children, or they may be pregnant as a result of rape or incest. So again, there are lots of conflicting and contributing circumstances that go into the reasons why someone may seek an abortion, including a whole host of other personal, financial, and emotional considerations that go into that. So at Planned Parenthood Advocates of Wisconsin, we really try to make sure that we're not specifically focusing on the reasons why any one individual might be making that decision. We think it's important to really focus on the fact that what we know and what we value around this, and I think what probably most people in this forum value is that we know that abortion is a deeply personal decision that needs to be made by the pregnant person, and it needs to be made by that pregnant person in consultation with their own values and with the people in their lives that they trust to make really important decisions. And that is absolutely not the place of politicians or judges or anyone else to be making that decision for them. So we really just try to make sure that when we are talking about the reasons and everything else that goes into someone's decision to have an abortion, is that the most important thing is that person is making the right decision for them and their circumstances. So there definitely, when it comes to abortion, there's definitely no shortage of myths out there within the general public about both why people get abortions and the general statistics around abortions in Wisconsin and the country. So one common myth is that after Roe versus Wade, abortions skyrocketed. That is not true. What we saw is a continued rise in abortions into the 70s and 80s, and since the 1980s, a pretty precipitous drop in abortions, both in Wisconsin and across the country. The reasons for the drop in abortions are numerous, but I think the most widely accepted reasons about that is significant advances in family planning, in the accessibility of family planning, and the increased effectiveness of modern contraception. Unfortunately, it's not just improvements in family planning practices and medication that has led to that decrease in abortions. It's also because abortion continues to be an incredibly regulated form of medical care. That includes in Wisconsin. So what we have seen is a lot of states pass significant restrictions on access to abortion, which has made abortion even with the protections of Roe versus Wade. Roe is not a reality for everyone, including in states like Wisconsin. So in the current landscape that we're already in, the same individuals that are facing health inequities, facing existing systemic barriers to accessing healthcare within our existing healthcare system, and facing existing socioeconomic barriers, also face those same barriers to navigating the various restrictions on access to abortion. So that tends to be people with lower incomes, people of color, and people living in rural areas who tend to face the existing health inequities that we see across systems, both in our society and across our health system. So those are the two main factors why abortion rates have continued to decline. Second is that abortion is actually a very dangerous procedure. That is absolutely a myth. Abortion is a very safe medical procedure, and as I mentioned earlier, is actually is far safer than going through a full pregnancy to term. And lastly is that there's often a myth that many people get abortions late in pregnancy. The vast majority of abortions in Wisconsin and across the country are actually during the first trimester of pregnancy, so during the first 13 weeks of pregnancy. And as Michelle mentioned, more and more abortions are being provided by medication abortion, which is generally only provided up to 11 or 12 weeks of pregnancy. So there are reasons why individuals definitely need to be able to access abortion later in pregnancy, but most abortions are being provided in the first trimester, and almost all abortions are being provided in the first 2 trimesters. So I talked about this a little bit in the previous slide. Want to just give a little bit more background to sort of the abortion access landscape in Wisconsin. So right now there are four health centers in the state of Wisconsin that provide abortion. 3 of those health centers are run by Planned Parenthood of Wisconsin. 1 health center in Milwaukee, 1 health center in Madison, and 1 health center in Sheboygan. And the Planned Parenthood of Wisconsin Sheboygan Health Center only provides medication abortion. Affiliated Medical Services is another abortion provider, and they have an abortion health center that provides abortion care in Milwaukee. So that probably seems to a lot of people like not a lot of abortion providers for a state as big and populous as Wisconsin, and that is definitely true. There's only 3 of the 72 counties in Wisconsin currently have an abortion provider. So more than 90% of our counties do not have an abortion provider, and that's partially because of how restricted abortion has become in the state. I'm not going to read all of these restrictions, but as you can see in the 3rd bullet point, there are over a dozen restrictions on access to abortion care that are on the books already in Wisconsin that are not restrictions that are applicable to any other type of healthcare. And those restrictions make it very difficult to run and effectively operate and staff abortion centers in the state of Wisconsin. And that is partially why we see so few abortion centers across the state, and why abortion, even under Roe, remains inaccessible for many people. So I wanted to also just share on the next slide a couple quick resources if people want to learn more both about abortion in general, but also about some of the existing policy and legal framework that goes on for both Wisconsin and the nation. The Guttmacher Institute is an amazing, very academically focused organization that provides excellent synopses of both policies and statistics about abortion. They also run full peer-reviewed studies around reproductive health care as well. Physicians for Reproductive Health is a great physician-run resource that is a national provider resource with additional information from a provider perspective. And then lastly, the Kaiser Family Foundation is a nationally renowned healthcare nonprofit that provides a wide range of information about abortion and other reproductive healthcare services.
Well, thank you both, Michelle and Mike, for that background and that information. We are going to turn our attention now away from more of the factual portion about abortion services and why it's an essential form of healthcare, and instead turn to the analysis of the most recent Supreme Court draft leak that took place at the beginning of the month, and what implications that this decision could have on the nation and then particularly Wisconsin as a whole. So Chris, I am going to rely on you here as one of our legal experts in the room. But before we dive into that, I think it's helpful to talk about some background context of Roe v. Wade and then the Hyde Amendment as well. I know Michelle spent a bit of time educating us on Roe v. Wade, which passed in 1973. And as we all know, this was a landmark case where the Supreme Court federally legalized abortion, making it a constitutionally protected right. However, in 1976, we did see the passage of the Hyde Amendment, which is a law that forbids the use of federal funds, such as Medicaid, to cover the cost of abortion services. And I just want to take a moment to note that we all know that reproductive rights is just a perfect example of intersectionality as an issue or topic area. And as we consider systemic racism and the impacts that it's had on our nation, we know by research through the Guttmacher Institute that most women of color are disproportionately likely to be low income and to be insured through Medicaid. So as we consider the Hyde Amendment, we really do see this having a disproportionate impact on women or people of color who can become pregnant. And that means that people of color in low income communities that may rely on Medicaid to cover healthcare costs would be precluded from using that to cover essential healthcare services such as abortion. So this is a great map sort of highlighting how the Hyde Amendment would impact certain states if Roe v. Wade is overturned. And Chris, I would love to hear kind of your take on, we know what Roe v. Wade, the decision was, but can you tell us a little bit more about sort of the legal nuances? How was it decided? What were the grounds for the decision of Roe?
Sure. So one thing that we haven't mentioned about Roe versus Wade is that the court was really considering, when does a state have an interest in regulating abortion? And the decision said that up until the point that a fetus is viable, this is a decision for the pregnant person. And the state has no interest because there's no possibility that this fetus can live outside of the pregnant person. So if, born today, if there was some complication in premature labor, this fetus would not survive. So that's where we get the standard of viability. And over time, because of advancements in the medical field, viability has, the point of viability has come earlier and earlier. And we now see that there are babies born at 23 weeks that are able to survive. And that's how Wisconsin's able to have a law that restricts abortion at 22 weeks after your last menstrual period. We mentioned 20 weeks earlier because it's 20 weeks after conception. So it's considered 22 or 20 weeks, depending on the starting point. So all that to say that in this decision, the court said viability is really the key point at which, after which the state can regulate. And when Mississippi passed this regulation recently saying that at 15 weeks, we're going to ban abortion, that was directly contradicting what Roe said, which is when a fetus is viable, a state can start regulating abortion. There's nowhere in the world where a baby can be born at 15 weeks and survive. That we don't have the technology for that. So this was like a direct assault on Roe, and it went up to the Supreme Court. And and I guess I'll mention that, Roe was also based on the 14th Amendment, which provided due process of law and also equal protection, and that we all have certain rights to be free, liberty rights. And so Roe was decided on the grounds that, liberty gives us a certain right to privacy. In order to be free in this country, we need to have a certain amount of privacy. And so although privacy is not stated in the Constitution, we can assume that. And that privacy necessarily includes rights about our personal health, like using birth control and terminating a pregnancy. Roe was not decided on the basis of equal protection, meaning women are disproportionately burdened with pregnancy, and therefore this is really an issue of equal protection and how we, treat people of different sexes. So that's important, simply because that's just not a challenge that's been brought based on abortion, and there's possibly a future there.
Thank you. That's helpful background context. And I want to take it a step further. Me not being a legal expert by any means, I think it's helpful if we can take a moment to just sort of talk about where this draft came from in the timeline or the process of the Supreme Court considering the case in front of them. So would you be willing to just dive a little bit more deeply into sort of where this draft is coming from and what its implications mean as we read it today?
The Supreme Court heard oral arguments in this case at the end of 2021. I think it was December. And the normal process for the court is, after hearing oral arguments, the justices all go back in conference. And this used to be done in person in a room, and I'm not sure how they do it these days, but they would go back into a room and they would take an initial vote, just, a simple hands up or an up down vote on how they would rule that day on the decision. And based on what the majority is at that point, so like in this case, they would go back and they would vote, and it looks like 6 of the justices said, I want to uphold the Mississippi 15-week ban. And so at that point, because there were 6 justices saying we want to uphold the ban, they would assign somebody, the most senior justice in that group, or the chief justice, would assign the person to write a draft opinion. And then that person would draft an opinion, circulate it to the other people in the majority, and the other justices would read it and say, I agree with this piece of the analysis, but not this piece. I think we should rework this. And they would essentially come to a decision that they all felt good about and agreed with. Sometimes the justices can't do that. And that's why you'll see multiple decisions that will uphold, they'll come up with the same decision, but they'll have different reasoning. So you'll see multiple concurrences. At the same time, the dissent would be writing its dissent. They would be doing the same thing. And then the justices would pass their decisions back and forth. So the dissent can see what the majority is saying, the majority can see what the dissent is saying. And this is how the conversation goes. It's largely in written form. So the decision that we saw come out was a leaked draft opinion that was written in February by Justice Alito. And we can tell that because it was we can tell from this decision that there are 5 judges that are signing on to Justice Alito's reasoning and totally overturning Roe. Now, we didn't get into the weeds, but there are multiple ways the court could have ruled on this Mississippi law, and only one of them completely overturns Roe and says there is no right to an abortion anywhere in the Constitution. That's what Justice Alito's decision said. And it looks like Justice Roberts wants to uphold the Mississippi law, but doesn't have the same reasoning.
And in terms of timing, Chris, I'm going to go back to that last slide and just say, at what point can we expect to hear the final ruling from the court? And I know in sort of general conversation, there's this big question of, is the court receptive to hearing some of the displeasure with this draft leak and the decision that is being put forth at this time? So what's your take on the court's opinion or ability to be swayed in their timing?
Well, we're expecting the decision to come out in late June, just because that's normally when the court releases its biggest, most controversial decisions. And they could release it at any time. that's, we really don't know. But traditionally, a decision like this would come out like the last week of June. They release decisions at, I think it's 10 a.m. Central, or it's 9 a.m. Central, 10 a.m. Eastern. And so we would know what the decision is by 9:30 Central Time, end of June. That's what we expect. And as to whether the court would be swayed, it's highly unlikely that the court would be swayed. The court and these justices really pride themselves on their independence and their immunity to public opinion. Many of them have said those things publicly. We're not a political body. These justices are appointed for a lifetime. So there is no decision that just based on the merits of it would get them kicked off of the Supreme Court. And I think, again, just how they see themselves as an institution that can't be swayed by politics.
Yeah, absolutely. I think it's helpful to understand some of the mechanics behind the draft that's been released thus far. And as we think about that final ruling coming out roughly sometime in June, we know that as it is currently written, our interpretation of it is that the federal Constitution will no longer protect the right to abortion, meaning that Roe v. Wade is overturned. And then essentially this just means that the decision is left up to the states, correct? Where we will have different states across the nation. We have about 26 that will have either a trigger ban or a pre-Roe ban go into effect if Roe v. Wade is overturned. So in the case of Wisconsin, we fall under that pre-Roe ban category, which is legislation that was passed prior to 1973 or the passage of Roe, which means that banning abortion could return to full effect if Roe is overturned. Trigger bans are a slightly different variety of a pre-Roe ban, but this is just legislation that was passed after 1973 as a preemptive sort of restriction if Roe were to be overturned in the future. And again, I'm just going to plug the Guttmacher Institute for being a great resource to kind of look at a state-by-state analysis of what the implications of this decision could look like on a state-by-state basis. And that means it's time for us to turn and look a little bit more closely at where we find ourselves here in the state of Wisconsin. So I am going to turn it over and ask Michelle to chime in here and tell us a little bit more about what could the overturn of Roe v. Wade mean for Wisconsinites.
Thanks, Abby. That's exactly right. There is a pre-Roe criminal abortion ban in Wisconsin. So Roe v. Wade being overturned has a significant impact on the access to abortion care in Wisconsin. The statute is 94004, and it's, I think, really important when talking about that pre-Roe criminal ban that we make sure people know that does not include the mother or the pregnant person who could be potentially criminally prosecuted for an abortion. So the pregnant person could not be prosecuted. I think that's really important. People know that, especially because that's not necessarily the case everywhere, as we're seeing the passage of more laws in other states that restrict or criminalize abortion. That being said, the criminal abortion ban is really a blanket ban. It is a Class H felony to provide an abortion, and post-quickening, which in Wisconsin means about 15 or 16 weeks of gestation, it is elevated to a Class E felony. There are no exceptions in this law if the person is pregnant as a result of rape or incest, or I'm sorry, that should say the health of the pregnant person. The only exception is for the life of the mother. So I just want to clarify that slide. That's the only narrow exception in this case. So really it means that people are going to be forced to either leave the state to access care or to continue with a pregnancy. And as Mike mentioned, that is not always the healthiest or safest option for people for a variety of reasons or desirable. And again, the most vulnerable and marginalized communities will be the most impacted. There's also concern around the perception of miscarriages, stillbirths, or other pregnancy related deaths. And people are worried about, private citizen reporting or new legislation that could make people either criminally or civilly liable, as we've seen in other states around the country. Texas is an example. Texas has had effectively a full abortion ban since September of 2021 with Texas SB 8, which delegates enforcement to the private citizen and makes an abortion provider or anyone who assists in providing an abortion in the state of Texas civilly liable, and they can be sued for up to $10,000. So people are really worried about what this means in terms of accessing other kinds of pregnancy-related health care. And when there is truly an emergency and the life is in danger, that there's an alignment or that there's an understanding of what that means. What does that life exception mean for doctors? And so we're concerned about, providers potentially and emergency room physicians being, potentially either confused or, just kind of worried about at what point they can assist in an abortion to save that person's life. We also have to consider prosecutorial practices. Attorney General Josh Kaul has publicly indicated that he would not enforce the pre-roll ban and that he would not put any resources of his office into the investigation or prosecution of abortion. But I think it's important for people to know that, while we appreciate, Attorney General Kaul's, position on that, and it's important to know that his office has a pretty limited jurisdiction, and that there are 72 counties in Wisconsin. And I think that a couple counties might share DAs, but there's about 70 different DAs in Wisconsin. So really enforcement is going to be up to the individual district attorneys and their staff. And it's also important to know that felonies in Wisconsin have a 6-year statute of limitations, and that DAs serve 4-year terms. So even if, for example, in Dane County, if that prosecutor wouldn't file charges against a provider in Dane County now, a new DA 4 years from now could absolutely look back and decide to prosecute at that time. And then lastly, the leaked opinion really was very stark in how it described there being no right to privacy in the Constitution. And so that absolutely raises, I think, the alarm on other types of rights that are protected under that theory of there being a right to privacy in that personal liberty, right? So those are things like marriage equality, contraception, child rearing, other kinds of medical treatment are all, and this is not an exhaustive list by any means, but those are all things that we need to be concerned about, I think. And then lastly, for the short-term and the practical implications, abortion providers, at least at Planned Parenthood of Wisconsin, will really have to just immediately pause or stop providing abortion services. And that's not necessarily because we're all in agreement that 940.04, that pre-Roe ban, automatically comes back to life, but it's because there's question or some doubt as to, there's some question about that, right? And so we couldn't risk the freedom and liberty of our providers and other staff, to face criminal prosecution. So while that sort of has to play out, Planned Parenthood of Wisconsin would be assisting patients in accessing care in other parts of the country or other states where it remains safe and legal. We are, in all of this, fortunate to have Illinois be a neighboring state where abortion is very accessible for our patients, or for Planned Parenthood of Wisconsin's patients, because they're able to use telemedicine, as was shown on one of those earlier slides. So it's a little more accessible. It's more accessible there than here, even now. Minnesota is another safe state where patients from Wisconsin can access. And then very recently, Michigan was successful in obtaining an injunction against the enforcement of their abortion ban. And so Michigan will also continue to provide abortion services. We've already sort of talked about life-threatening pregnancies, for example, an ectopic pregnancy. I think that's going to make some doctors and other medical providers just reluctant to provide a therapeutic abortion when necessary, because the law, again, is unclear as to what is the point at which the pregnancy is considered life-threatening enough so as to not implicate 940-04 if that doctor provides an abortion. And then lastly, Planned Parenthood of Wisconsin will not just help people with, making appointments and locating the best place for their abortion, but also providing early pregnancy assessments. So that way, when they're accessing their care in other states, they know that they can keep that appointment because they have the right gestational aging. So they've made the right appointment. They've had all of their health history and lab work done. As well as providing the actual resources to leave the state. So assistance with transportation or financial assistance for childcare or other financial losses or needs that occur for having to leave the state, and then continued healthcare upon return.
Thank you, Michelle. So we now kind of have a better understanding of what this could all mean for Wisconsinites as we look to the future. And I want to, again, turn our directions to what can we do to help or to mobilize around this really important issue. And again, I'm going to look to our legal experts in the room between Chris and Michelle. Would love to hear your thoughts on different approaches or strategies and maybe some scenarios for the state moving forward as to what this ruling could mean come June 2022.
Sure. So this is now a state matter, and it's going to come down to the state legislature and the state Supreme Court. Now, the legislature is firmly in Republican hands, and it looks like the maps that were just approved, the congressional maps that were just approved by the state Supreme Court, are going to give Republicans an even stronger majority. People have talked about whether there's a possibility that the Republicans could get a veto-proof majority, which I think means 66 votes. I was just at a presentation yesterday with some political scientists, and they think that's extremely unlikely. It's very unlikely, but it is possible based on the maps. So if there's a Democratic governor, that Governor Tony Evers could veto legislation from the legislature right now. Now, when it comes to, but if there's a Republican governor, then presumably there could be all sorts of different types of laws passed, laws that you're seeing in other states, like the private enforcement law in Texas, further restrictions that maybe don't have exceptions for the life of the mother, or possibly even criminalize attach liability to the mother. So we could see a whole host of new types of abortion regulations if we have a different governor. And then when it comes to the state Supreme Court, there's going to be litigation, like Michelle was talking about, to define some of these issues that are maybe confusing or vague. Does this pre-Roe ban even go into effect immediately? There's going to be litigation to try to sort some of that out, and that's going to go straight to the state Supreme Court. Michelle, do you want to, should I say a little bit more about the state Supreme Court, or Michelle, do you want to jump in?
You can go ahead.
Okay. So right now, based on what the state Supreme Court justices have said publicly, it certainly seems that they would uphold a variety of abortion restrictions, including this pre-Roe ban. But there is this election in spring of 2023, and depending on who wins that election, the court could change its makeup and have a very different take on a variety of abortion regulations. So that election is going to be extremely important, as is the governor's election in determining the future of reproductive rights for sure in the state.
Yeah, that's, I think, 100% correct, Chris. And I think if there's one takeaway for people, it's that abortion access is a state-controlled issue. And so we no longer have the constitutional backstop from the United States Supreme Court decision. Decision in Roe. We cannot rely on the federal courts to protect abortion in Wisconsin. And so more than ever, who the people are, enacting laws and reviewing the applicability and the constitutionality of our laws is important.
Absolutely. And Chris, I feel like you did a nice job, and Michelle, you as well, kind of the two different scenarios we could potentially find ourselves in the state as we look ahead to these two future elections. So in the first scenario, we're kind of talking about not only a pro-choice governor, but also a governor that is pro-voting rights. And I'll go a little bit more into why that matters if they win in the November 2022 election. And what that means then for the state is that, some of those more nefarious bills in the legislature are vetoed through that governor power, and we don't see Wisconsin backsliding even further. And the other point with a pro-voting rights governor is this idea that we will hopefully see a more sort of friendly, welcoming environment and mobilized environment for voting come not only that 2022 fall election, but as we look ahead to that spring 23 election that we just highlighted as being important for the, potentially creating greater judicial protection for reproductive rights. And then on the other hand, we have the second scenario where we could end up with an anti-voting rights governor and an anti-choice governor, which again, we see sort of abortion right risks having further criminalization, put more risk on health and safety of our state citizens. And this then also lends itself to a less than hospitable voting environment, making just potential comfort on going to voice, exercise your right to vote in 2023 more challenging. So it becomes more of an uphill battle. It's not impossible, but it does create some barriers and maybe a hostile voting environment as well.
I just want to add that the state is really 50-50. When you look at all the elections from the last 10 years, especially, when you look at statewide races and presidential elections, these elections are won by 25,000 votes. And so when it comes to like conservative Democratic in this state, it's really, really 50-50. But because of gerrymandering, Republicans have a really strong hold on the legislature. So I don't see that turning and becoming, Democratic anytime soon, but that there's a real chance at a Democratic governor. And the state Supreme Court elections, of course, are statewide elections. And so those are always very close, 50-50. So yeah, it really could go either way when it comes to the governor's race.
Well, Chris, it's almost like you set me up perfectly for our next slide, which hopefully this comes as no surprise to any of our attendees today, that in terms of probably the most impactful way that you can make a difference surrounding these issues of reproductive rights and abortion care services is to get out and vote. And I can't stress enough that now is the time. Please open a tab on your browser, open your calendar on your phone, go and mark these dates down and start making your voting plan now. Decide, are you going to go vote in person? Are you going to use early voting sites, or are you going to take advantage of absentee ballots? But there is no time like the present to make that voting plan and stick to it. And for those of you that maybe are going, well, okay, I don't even know where to start, we have fantastic resources available for the state. So My Vote Wisconsin should be very much in your back pocket for all things election related. You can go register to vote, make sure your registration is current, your address is current, request an absentee ballot, which you can do for an entire year's worth of elections. Learn about where your polling place is, find out more information about early voting. Literally any question you have regarding the right to vote can be found on My Vote Wisconsin. So that's a huge resource for Wisconsinites. And if you are listening to me talk about going and voting and how important it is to be a voter, and you're like, I've been doing this for years, I have this down pat, what more can I do? The answer is a lot. So we always are always in need, always searching for folks to go and volunteer at the polls. So we always need more poll workers. This is something that you can volunteer to do. You can sign up to be trained and also be an election observer, again, making sure that people have the ability to vote comfortably and with assistance if needed. So please take the time if you're looking to up that engagement in terms of voting rights work. There are plenty of opportunities for you to get involved on a local level. And even beyond voting rights, another program that we offer through the ACLU of Wisconsin is our legal observation program. So we have volunteers who are trained to attend public demonstrations or protests, marches, where there could be the potential for conflict between law enforcement officers and the people participating in that demonstration and protest. So legal observers aren't participants, but they are merely there to sort of monitor, record, and hopefully deter any sort of escalation between the folks that are exercising their right to gather and to make their voices heard and between law enforcement officers. So this is a program that we are working on refreshing our training, and we are gathering, hoping to gather more interested participants. So I will drop a link in the chat once we are done with the full presentation. So if folks are interested in signing up to receive information about those trainings, you will do so, or you'll be able to do so in the near future. And another opportunity too is we are looking to gather a team of volunteers who want to go out into their communities and host town halls or informational forums like this one. So spreading information, helping people understand some of the complexities around these issues that are, you know, really nuanced and really, really deep. And it just takes a little bit of time and sometimes a friendly face to help unpack all of the different layers and all of the different levels. So if you are sitting here going, yeah, I'm an educator, or yeah, I'm really plugged into my community, I'd love to have the opportunity to share this information. We also will be hosting trainings about how you can do that and help you tailor whatever sort of presentation you're looking to bring to your network. So again, I will drop a link in the chat shortly, but also have to give a shameless plug to our social media feeds, at least for the ACLU of Wisconsin, Planned Parenthood. Sorry, I wasn't able to add yours on before the start of our presentation today, but I'm sure you can find them as well through all of their social feeds. And I just really want to take a moment to thank our panelists for being here today and for your time, your knowledge, your expertise. And I am going to take a peek now at the Q&A and see if we have any questions that have come in from our attendees. And right now it's looking awfully quiet, but if there are questions, attendees that are sort of rattling around in your head, please feel free to drop those into the Q&A portion. We have about 5 minutes left to maybe answer one of those. And then in the chat, I have just shared the 2 volunteer training sign up links if you're interested in either becoming a legal observer or an education facilitator for town halls like this one. I'm going to give it one more minute before we close, but I'm not seeing anything yet coming through that Q&A.
Abby, thank you for putting this on before we close.
Of course, happy to be here. Again, I'm seeing folks beginning to sign off. So I think with that, we will wrap this up. Thank you to all of the attendees. And again, thank you to the panelists for being here to talk about this really important topic today. Have a great rest of your afternoon. And we hope to see many of you either in a volunteer capacity or at other town halls and educational opportunities like this one. Thank you and have a great rest of your night.
Thank
Thanks,
you.
everyone.